Part 2 of study session with, and we're worried, so we're going to come back here to B, and we're under, so I'm going to read this whole thing. 115, incomplete instrument. You don't want to do that, but A, incomplete instrument means a signed writing, whether or not issued by the signer, the content of which shows at the time of signing that it is incomplete, but that the signer intended it to be completed by addition of words or numbers. Incomplete instrument means a signed writing, whether or not issued by the signer, the content of which shows at the time of signing that it is incomplete, but that the signer intended it to be completed by the addition of words or numbers. B, subject to subsection C, if an incomplete instrument is an instrument under section 3-104, it may be enforced according to its terms if it is not completed, or according to its terms as argument by completion. If an incomplete instrument is not an instrument under section 3-104, but after completion, the requirements of section 3-104 are met, the instrument may be enforced according to its terms as argument by completion. B, again, subject to subsection C, if an incomplete instrument is an instrument under section 3-104, it may be enforced according to its terms. If it is not completed, or according to its terms as augmented by completion. If an incomplete instrument is not an instrument under section 304, but after completion the requirements of section 3-104 are met, the instrument may be enforced according to its terms as augmented by completion. C, if the words or numbers are added to an incomplete instrument without authority of the signer, there is an alteration of the incomplete instrument under section 3-407. D, the burden of establishing that words or numbers were added to an incomplete instrument without authority of the signer is on the person asserting the lack of authority. So to be on you. Alteration. Section 347. Alteration. 347. Alteration A means an unauthorized change in an instrument that purports to modify in any respect the obligation of a party, or an unauthorized addition of words or numbers or other change to an incomplete instrument relating to the obligation of a party. B, except as provided in subsection C, an alteration fraudulently made discharges a party whose obligation is affected by the alteration, unless that party assents or is precluded from asserting the alteration. No other alteration discharges a party, and the instrument may be enforced according to its original terms. C. A payor, bank, or drawee, paying, a fraudulently altered instrument, or a person taking it for value in good faith and without notice of the alteration may enforce rights with respect to the instrument, I or one according to its original terms. So you always go back and enforce your rights to the original terms. Or I, in the case of an incomplete instrument altered by unauthorized completion, according to its terms, is completed. And I wanted to come back here and we just did. So if the words or numbers are added to an incomplete instrument without authority of the signer, there is an alteration of the incomplete instrument under section 3407, meaning you altered it without my consent, and I can always go back and claim those rights to that instrument, to the original terms. Issue of instrument. So I think I was dissecting this. So an unissued instrument or an unissued incomplete instrument that is completed is binding on the maker or drawer, but non-issuance is a defense. An instrument that is conditionally issued or is issued for a special purpose is binding on the maker or drawer, but failure of the condition or special purpose to be fulfilled is a defense. So you didn't do what you had to do. So now I'm at defense. Them. Anything with the ER is them. And the EEs is us. E. Issue E. Unless you doing a promissory note, then you are the maker. A promissory note is a promise to the order to a special person or bearer, and I'm using kind of plain language, to an unconditional order of an undertaking or promise. It has to have a stamp and it has to have all the requirements, but nobody made it. You just made a promise. Or to the best of my knowledge and understanding right now is if you get like if we go to a phone company, they give you a contract and on it there's no signature from them. Then you can make a promise to pay because they didn't put their value to the asset or to the contract or the instrument. A bill of exchange would be, they handed it to you. They got their signature. And all you do is pay to the order of, an unconditional order to pay to the order of. You don't need a stamp. And all you got to have is the requirements and proper endorsement. Pay on demand. identification of, okay, let's see this pay on demand, because that's like, whenever, so pay on demand, you do that if your bill outdate, like, what I'm saying, is overdue. And you just, like, just say, what I'm saying, the bill was due today is the 24th, and the bill was due on the 22nd. You just cross out the date and put payable on demand. So let's see. 3108, payable on demand or at definite time. A promise or order is payable on demand if it states that it is payable on demand or at sight. So payable on sight, payable at sight, or otherwise indicates that it is payable at the will of the holder, or does not state any time of payment. Go ahead, uh, man, doing business as T-Mobile. Man, make it payable whenever. I mean, just go cash whenever, whatever. Go to the bank with it whenever you want. Go get these credits on site, or what I'm saying, to the will of the holder. Whenever you get it, pay to the holder. Whenever you ready to go, go get you. It's at your will. B, a promise or order is payable at a definite time if it is payment. Wait, if it is payable on elapse of a definite period of time after sight or acceptance, or at a fixed date or dates, or at a time or times readily ascertainable at the time the promise or order is issued, subject to rights of repayment, acceleration, III, extension at the option of the holder, or 4, extension to a further definite time at the option of the maker or acceptor, or automatically upon or after a specified act or event. A promise or order is payable at a definite time if it is payable on elapse of a definite period of time after sight or acceptance, or at a fixed date or dates, or at a time or times readily ascertainable at the time the promise or order is issued, subject to rights of repayment, acceleration, extension at the option of the holder, or extension to a further definite time at the option of the maker or acceptor, or automatically upon or after a specified act or event. You will have this wedding, a specified time or event. And I make because I won't be here, I make that instrument payable at a definite time, like right at the wedding. Whenever you get married to this family, this clan's daughter, at a later period, I won't be here. You will have this instrument waiting for you, and you'll get five different payments. at this date, this date, this date. A fixed date or dates, or at a time or time readily ascertained at the time the promise or order is issued. All right. C. If an instrument payable at a fixed date is also payable upon demand made before the fixed date, the instrument is payable on demand until the fixed date. And if demand for payment is not made for that date, becomes payable at a definite time on the fixed date. If demand for payment is not made before that date, becomes payable at a definite time on the fixed date. See, if an instrument payable at a fixed date is also payable upon demand made before the fixed date, the instrument is payable on demand until the fixed date. And if demand for payment is not made before that date, becomes payable at a definite time on the fixed date. I just want to read this one. Well, I know you mad, fool. Mama. But you can sit down. 3107. Instrument payable in foreign money. Unless the instrument otherwise provides an instrument that states the amount payable in foreign money may be paid in the foreign money or in the equivalent amount in dollars calculated by using the current bank offered spot rate at the place of payment for the purchase of dollars on the day on which the instrument is paid. You mean to tell me that I can make this payment in pesos or a currency that's higher than the United States, and they got to give me the equivalent of Achibonachi Miyushi? Am I reading this right? Man. Doop-a-doop-a-doo. So who got the highest rate of currency? And since negotiable instruments come from India, the Indian Negotiable Instruments Act, I could make it payable in rupees. Thank you. Thank you. Let's go back. Unconditional order signed by the maker. What you gonna do now? Just how far will you go? 3110, identification of person to whom instrument is payable. A person to whom an instrument is initially payable is determined by the intent of the person. The intent by the person. Let's see. I could do a new tab. Legal definition of intent.
Is the acts or knowledge of the defendant.
Intent generally refers to the mental objective behind an action. The mental objection behind an action. The concept of intent is often the focal point of criminal law and is generally shown by circumstantial evidence such as the acts or knowledge of the defendant. So it's the mental objective behind an action. What is your intent? What is the mental? That's coming from Cornell. What is intent in Black's law? Purpose, formulated, designed, resolve to do or forbear a particular act, aim, determination. What is intent in Black's law? What are 3 types of intent? 3 types of we don't want to know criminal intent. Hey, thinking criminal. General intent, which is presumed from the act of commission, such as speeding. Specific intent, which requires pre-planning and predisposition, such as burglary. And 3, constructive intent, the unintentional results of an act, such as a pedestrian death resulting from. See, that's criminal intent. I'm looking for intent, man. Just plain old intent. See, plain old intent. Plain old intent. Criminal intent. Criminal intent. The act or fact of intending as the design or purpose of committing a wrongful or criminal act called is criminal intent. Compare knowledge, mens rea, motion, negligence. For the purpose of committing torturous, I don't want to hear that. Constructive intent, intent that is inferred to exist from willfulness or recklessness. Mental objection behind an action. What is your mental objection behind your action? Is it in good faith? Is it with sound right conscience? Is it for good reason? Is it with clean hands? Do you intend to do this righteously? Or are you going in to be deceptive? How is intent proven? A specific intent. In California, most crimes require a general intent. If that criminal act is completed by taking action, general intent can be proven by showing that you intended to perform the act. Some criminal acts are the failure to take an action at the status requires. Specific intent crimes typically require that the defendant intentionally commit an act and intend to cause a particular result when committing that act. Woo! I'm still eating. Thank you. So intent. Go back. That's what I think. Oh. Excuse me. All alone you never were my That's why I treat yourself like I'm a. So a person to whom an instrument is initially payable is determined by the intent of the person, whether or not authorized, signing as, or in the name or behalf of the issuer of the instrument. The instrument is payable to the person intended by the signer, even if that person is identified in the instrument by a name or other identification that is not that of the intended person. If more than one person signs in the name or behalf of the issuer of an instrument, and all the signers do not intend, the same person is payee. The instrument is payable to any person intended by one or more of the signers. If the signature of the issuer of an instrument is made by automated means, such as a check writing machine, or payee of the instrument is determined by the intent of the person who supplied the name or identification of the payee, whether or not authorized to do so. C. A person to whom an instrument is payable may be identified in any way, including by name, identification number, office, or account number. Your social security account. Thank you. Or EIN number. What? Driver's license number. What? You got so many numbers. For the purpose of determining the holder of an instrument, the following rules apply. Okay, battery about to die on this one. If an instrument is payable to an account and the account is identified only by number, the instrument is payable to the person to whom the account is payable. If an instrument is payable to an account identified by number and by the name of a person, the instrument is payable to the named person, whether or not that person is the owner of the account identified by number. 2, if an instrument is payable to a trust, an estate, you're an estate. Don't you have a trust? I don't know, like a trust or a person described as trustee. So all these treasurers and stuff is the trustee. We just the beneficiary or representative of a trust or estate. We are the representative of the trust and estate by way of birth certificate registered with the state of here, Louisiana. The instrument is payable to the treasury, to the trustee. The instrument is payable to the trustee, the representative, or the successor, or either, whether or not the beneficiary or estate is also named. A person described as agent or similar representative if a named or identified person, the instrument is payable to the represented person. The representative or a successor of the representative, i.e., a fund or organization that is not a legal entity. The instrument is payable to a representative by the members of the fund or organization or an office or to a person described as holder and as holding an office. The instrument is payable to the named person. The encumbrant of the office or the successor to the encumbrant. And I think that's where we have to go. Legal definition of encumbrant.
According to law, Cornell University, an encumbrance is a claim against an asset by an entity that is not the owner. Common types of encumbrances against real property include liens, easements, leases, mortgages, or restrictive covenants.
Encumbrance impact the transferability and or use of subjected properties. So an encumbrance is a claim against an asset. Whenever they hand you that contract, that is the company's, once he put his signatures, that is an asset by an entity, business, all kind of entities. You could make entities. That is not the owner. That is not the owner. So maybe if I put the I, let me do this. I think I didn't go back to the right one. Don't know. I'm gonna have to kill this because the battery right down on this one. So thank you for tuning in, studying with I. Peace be upon thee. I will keep going for a little while. And I gotta get back to these acts. Peace, y'all.